That is all for us here at Now. I'm Alex Wagner. The Rachel Maddow Show starts right now. Good evening to you, Rachel.
Good evening, Alex. Thank you very much. And thanks to you at home for staying with us this hour. The first thing you need to know about arguing a case before the United States Supreme Court is that the justices of the United States Supreme Court really do not care about whatever it is you were planning on saying to them.
We'll hear argument this morning in Case 12-144, Hollingsworth versus Perry. Mr. Cooper.
Thank you, Mr. Chief Justice, and may it please the Court. New York's highest court, in a case similar to this one, remarked that until quite recently, it was an accepted truth for almost everyone who ever lived in any society in which marriage existed.
Mr. Cooper, we have the jurisdictional and merits issues here. Maybe it'd be best if you could begin with the standing issue.
Humility. First lesson today is humility. The lawyer for the anti-gay rights side of the case was allowed to basically gesture at his first citation, to teeter on the precipice of his first appendant clause, when, bam! This is not your house, sir. This is the justice's house. And they apparently have business to attend to in this case that does not afford time for your little essays. The case today was, of course, the first of two big gay marriage cases the court is hearing this term. The next one's going to be heard tomorrow. People lined up overnight in the snow to get into the courtroom to hear these arguments today. People even paid other people to stand in line for them if they did not want to brave the elements themselves and they had spare cash. When everybody did get in this morning and when things got going inside the courtroom at 10 a.m., it was clear that whatever you thought of the caliber of the lawyers arguing the two sides of this case, honestly, the people to listen to were the justices themselves, in part because that tips their hand about how they might vote, but also because they barely let the lawyers get a word in edgewise on both sides.
Mr. Olson?
Thank you, Mr. Chief Justice, and may it please the Court. I know that you will want me to spend a moment or two addressing the standing question, but before I do that, I thought that it would be important for this Court to have Proposition 8 put in context. What it does, it walls off gay and lesbians from marriage, the most important relation in life, according to this Court, thus stigmatizing a class of Californians based upon their status and labeling their most cherished relationships as second-rate, different, unequal, and not okay.
Mr. Olson, I cut off your friend before he could get into the merits, so I think
I was
it's
trying
fair.
to avoid that, Your Honor.
I know you. I think it's only fair to treat you the same. Perhaps you could address your jurisdictional argument.
The lawyers on both sides today, both trying to start with the big picture, with the implications of today's case. Should gay people in America be allowed to get married? Is it right or wrong? Is it constitutional or unconstitutional for states to ban them from doing so? They're both trying to start with the big picture, but the justices basically would hear none of it. Well, they did hear some of it, and we'll have more on that in a second. But mostly, the headline out of today, and the bulk of the time today, was spent on something else that the justices wanted to talk about. They wanted to talk about whether or not this is the right case. Whether this case about California's gay marriage ban is the right type of case, asking the right type of question by the right questioners for the court to use this case to make a national decision on same-sex marriage rights. And the predictions from most court watchers are that the justices seem to not think this is the right kind of case. Now, if those predictions are right, and nobody knows if they will be, remember when CNN declared that health reform was dead? Yeah, there's no need to jump the gun with the predictions. We will have a decision in due time. But if the predictions are correct, that a majority of the court does not want to make this case the basis of a ruling with national implications for banning same-sex marriage, then the most likely other income could be that the lower court ruling in this case would be allowed to stand, in effect. That lower court ruling struck down California's gay marriage ban. So if that happened, gay marriage would be unbanned in California, and couples there would have the same rights to marry as couples in Iowa and Massachusetts and D.C. and the 7 other states that recognize equal marriage rights. That would mean that no state that bans gay marriage now would have that ban overturned. It would mean that no state that allows gay marriage now would have that overturned. It would also mean that no states that recognize civil unions but not gay marriage now would forcibly have those civil unions converted to marriage either. That seems like maybe it could be the most likely outcome of today's case. But honestly, who knows? Ted Olson, the lawyer, was asked after the arguments today what he thinks the court is going to do, having stood there toe-to-toe with the justices and talking to them for an hour. He was asked what he thinks the court is going to do, and his answer was, and I quote, "No idea." But we did get to hear the justices at length today on not just the procedural issues, but also the issue of gay marriage and gay civil rights more broadly. And what they said on those issues today not only was fascinating, but it may have even bigger implications for the other half of this issue, which is going to be heard tomorrow. Tomorrow, it isn't a single state's ban on gay marriage that's up for review like it was today. Tomorrow, the arguments are about a federal law, the Bill Clinton-era Defense of Marriage Act, DOMA, which says that even though a marriage in any one state is a marriage everywhere in the U.S. for straight people, marriages of gay couples are not guaranteed recognition outside of the state where they got married, nor can those marriages be recognized federally. That's what DOMA is. And knowing that the fight over that is coming down the pike tomorrow, that made exchanges like this one I want to play for you between Chief Justice John Roberts and the Republican former Solicitor General Ted Olson. That made this exchange really interesting. Listen.
So it's just about the label in this case.
The label is like
same-sex couples have every other right. It's just about the label.
The label marriage means something. Even our opponents.
Sure. If you tell a child that somebody has to be their friend, I suppose you can force the child to say, "This is my friend," but it changes the definition of what it means to be a friend. And that's, it seems to me, what the supporters of Proposition 8 are saying here. All you're interested in is the label, and you insist on changing the definition of the label.
It is like you were to say you can vote, you can travel, but you may not be a citizen. There are certain labels in this country that are very, very critical. You could have said in the Loving case, you can't get married, but you can have an interracial union. Everyone would know that that was wrong.
Chief Justice John Roberts and Ted Olson there arguing about whether this marriage label really means something or whether you can have first-class citizenship while the state still bans you from having that label, that one thing. If you wanted to know today if there was any good old-fashioned, fact-free, homophobic ignorance on display in the court, yes, that did arrive today on the wings of a dove named Justice Antonin Scalia. Justice Scalia starts here trying, quite overtly, to help out the lawyer who is arguing the anti-gay rights side. He starts out trying to help out the lawyer, and then he goes right off the cliff.
Mr. Cooper, let me give you one concrete thing. I don't know why you don't mention some concrete things. If you redefine marriage to include same-sex couples, you must permit adoption by same-sex couples. And there's considerable disagreement among sociologists as to what the consequences of raising a child in a single-sex family, whether that is harmful to the child or not. Some states do not permit adoption by same-sex couples for that reason. I don't think we know the answer to that. Do you know the answer to that? Whether it harms or helps the child?
No, Your Honor. And there's
but that's a possible deleterious effect, isn't it? They're arguing for a nationwide rule which applies to states other than California, that every state must allow marriage by same-sex couples. And so even those states that believe it is harmful, and I take no position on whether it's harmful or not, but it is certainly true that there's no scientific answer to that question at this point in time.
And that, Your Honor, is the point I am trying to make.
That actually was a point that the lawyer had not been trying to make at all before Justice Scalia decided he was going to help him out by handing him that one. That fact-free assertion about the social science on kids with gay parents that, in fact, is not at all borne out by the actual social science. Hearing Justice Scalia go there is sort of to be expected with him at this point. What was less expected, and therefore more interesting, was hearing Justice Anthony Kennedy, the swing vote, right? Justice Kennedy, right after that happened, just a few moments later, he interjected himself, going out of his way to kind of smack Justice Scalia's argument out of the water.
On the other hand, there is an immediate legal injury or what could be a legal injury, and that's the voice of these children. There's some 40,000 children in California, according to the Red Brief, that live with same-sex parents. And they want their parents to have full recognition and full status. The voice of those children is important in this case, don't you think?
Everything Justice Anthony Kennedy says, in most cases, but also in a case like this, is watched very, very closely, because Justice Kennedy is often seen as the pivot point, as the swing justice between the court's conservatives and the court's liberals. So we do have some experts on deck tonight to help us out with what all of this means. But before we get to them, because of the importance of Justice Kennedy, I just want to play one more moment of the case for you today. This is a moment where Justice Kennedy, again, jumps in at a time when it seemed like he didn't really have to, but he jumped into the middle of a point that was in progress between the more progressive justice, Elena Kagan, the Obama nominee, right? It's between Elena Kagan and the lawyer for the anti-gay rights side. So they're having a little tete-a-tete about something. You'll hear Justice Kagan first, but then listen to how Justice Kennedy jumps in.
What harm you see happening, and when and how, and what harm to the institution of marriage or to opposite-sex couples? How does this cause and effect work?
Once again, I would reiterate that we don't believe that's the correct legal question before the court, and that the correct question is whether or not redefining marriage to include same-sex couples would advance the interests of marriage as opposed
to... Well, then are you conceding the point that there is no harm or denigration to traditional opposite-sex marriage couples? So
no,
you're conceding that?
No, Your Honor, no. I'm not conceding that.
Well,
I've got two.
Then it seems to me that you should have to address Justice Kagan's question.
Thank you, Justice Kennedy.
You should have to answer the question then. Reading the justice's intentions is like reading tea leaves. It's fun, but it tells you more about the reader than the readee. But from the dominant focus of the arguments today, we know that the justices care very much about how this case got to the court. Specifically, the decision of the California governor and the California state attorney general to not defend Prop 8 in court. That is what they were focused on today. And joining us right now, live, is the Attorney General of the state of California, Kamala Harris. Attorney General Harris, thank you so much for being with us tonight. It's a real pleasure.
Glad to be with you. Thank you.
So Prop 8 passed in California in 2008. As I understand it, when you won statewide office a couple of years after that, you said that if you were elected, you would not defend that ban in court. Why did you make that decision, and how do you think it's playing out?
You're exactly right. I did, and we should also note that my opponent said that he would defend Prop 8, and of course, my opponent was not elected. And the reason I said that, and the reason I have refused to defend Prop 8 is one simple reason. It's unconstitutional, and it's actually been found by a court to be unconstitutional. And frankly, Rachel, as the daughter of parents who were active in the civil rights movement, I refuse to stand in the doorway of the wedding chapel blocking same-sex couples' ability to marry.
What do you think the practical effect is going to be of the justices focusing so intently on the standing issue, on that question of you not defending this case, you not defending Prop 8, but instead people who supported the initiative who weren't necessarily employees of the state taking it up instead of you? How do you think that's going to play out?
Well, Article 3 of the Constitution requires that if someone is going to go before the United States Supreme Court and take a position, they have to have some direct stake in the outcome. And our position all along has been Mr. Hollingsworth has no direct stake in the outcome. And in fact, his life will be impacted in no way by Miss Perry's ability to marry her partner of 16 years with whom she shares a child. So on the issue of standing, we I think, make the very obvious point that if you have nothing at stake in the outcome of this, you need to sit down. The other piece of it is that when we look at the impact to so many people. We're talking about an issue that is a fundamental right. The United States Supreme Court, since the 1880s, Rachel, 14 times, has described marriage as a fundamental right. So we can have the conversation that is about freedom to marry, but I think we really also must have this conversation about deprivation of fundamental rights. And what are we as a society going to do about that? And that's why I'm troubled by the conversation that suggests we should wait. We should not wait when people are being deprived of their fundamental rights. That's why we could not wait when the Lovings wanted to get married in Virginia. There has to be something about a civil society that says that we're not going to wait for the majority to be comfortable with the minority receiving and the full benefit of fundamental rights, rights that we outlined a long time ago, rights to liberty and freedom and equality.
When you look back at that vote in 2008 that brought Proposition 8 around in the first place, it was such a national surprise on a night when Barack Obama was elected, when so many Democrats were elected in both the House and the Senate, to see California of all states, passing that constitutional amendment. I guess two questions. One, should it have ever been on the ballot in the first place? And if it were again, how do you think the vote would go now?
Well, I can tell you today 61% of Californians are in favor of same-sex marriage, as are the majority of Americans, as are the majority of Catholics in this country, as is the President of the United States, the former President of the United States, the former Secretary of State, heads of Fortune 500 companies, 100 of the top thought leaders in the Republican Party, athletes. The world has changed, and I think that what is clear is that were the vote to be taken today in California, I am sure Proposition 8 would not pass. But there is something fundamental also about allowing people to register their vote and to vote as they will. But right now, in California, 61% are in favor of same-sex marriage, and for a number of obvious reasons that have everything to do with just very fundamental principles, again, of liberty and freedom and equality.
Kamala Harris, the Attorney General of the state of California, who was not officially part of the case today, but by virtue of that ended up being very much the focus of discussion all day, even as justices on both sides called you he, as if you were a hypothetical person.
I'll tell you something. I think that's just further example of people needing to see that times have changed, and actually the first woman has been elected Attorney General of California.
Well, I felt for you, as somebody who gets mistaken for a boy when people can see me, I felt for you knowing that people were thinking that you were a man simply because of your job title.
Oh, wow.
It was an amazing thing. Kamala Harris, congratulations. Thanks very much.
Thank you.
All right, huge news day. We've got much more on the Supreme Court and same-sex marriage. We've got more Are You Kidding Me news out of the High Plains today. And on a totally different story, we've got somebody here for the interview later on tonight who we have been trying to get on this show for months. It's a big story, and that's ahead.